He's the California man accused of murdering 4 college girls with his speeding BMW on the infamous PCH along the coast. Prosecutors say this wasn't an accident. This was more than that. Fraser Bohm is charged with 4 counts of murder for what allegedly happened to the Pepperdine students on an October night in 2023.
Murder requires proof of a very particularized mental state. They argued it. There was a counter argument that we couldn't make because they didn't provide the data and the information to us.
Bohm could spend years.
He's 22-year-old Fraser Bohm, the privileged son of a wealthy family, handed a BMW for his Sweet 16 and now facing 4 counts of murder after plowing into 4 Pepperdine University sorority sisters on a deadly stretch of the Pacific Coast Highway one October night in 2023. And this week is high-powered defense attorney Alan Jackson.
The defendant in the story we're talking about today, Fraser Bohm, is facing the same amount of murder charges as Brian Kohberger did in Idaho. That is something that Fraser Bohm's attorney, Alan Jackson, brought up at a previous court hearing, as he has been arguing that this should not be a case involving murder charges.
Your Honor, this case, I've said it before and I will reiterate, is deeply, deeply tragic. And that cannot be overstated. But tragedy can't substitute for probable cause for murder charges.
So there's Alan Jackson arguing a motion to have the murder charges dropped in a courtroom this week in Malibu. Now, we'll get more into what Jackson had to say in a moment and what the judge decided. Now, you will remember, if Alan Jackson looks familiar, that is the attorney who represented Karen Reed. He is one of the biggest names in criminal defense. And before we get into what he had,
the same legal gladiator who repped Karen Reed launched a blistering counteroffensive in a Malibu courtroom, accusing the prosecution of a breathtaking discovery ambush, withholding crash statistics, cell phone forensics, and an inconvenient DUI report that he says eviscerates the very foundation of the murder charges, all while the grieving families of
took place. And it was October 17th, 2023. Fraser Bohm was allegedly going more than twice the speed limit. And these 4 girls were getting out of a car on the shoulder of the PCH. 20-year-old Neam Rolston, 21-year-old Peyton Stewart, 21-year-old Asia Weir, and 21-year-old Deslyn Williams. The 4 girls were sorority sisters at Pepperdine. They were seniors. They were just months away from graduating college and continuing on with their lives, really just starting their lives. But police say Bohm hit them with his car, and all 4 girls died. And the area of highway where Bohm hit them is known.
Neam Rolston, Peyton Stewart, Asha Ware, and Deslyn Williams watched a legal battle pivot from the asphalt and shattered glass of dead man's curve to a constitutional clash over due process in the razor-thin line between vehicular manslaughter and implied malice murder. The core of Jackson's argument, laid out in a motion to dismiss those 4 murder counts, is as audacious as it is meticulous. He claims that
is what he said.
The motion asks the court to dismiss counts 1 through 4 and 1 through 4 only, the murder counts, because the preliminary hearing on those counts and those counts alone, according to this motion, were fundamentally compromised. The prosecution withheld the very evidence that would have allowed the defense to show at the preliminary hearing that speeding on that particular stretch of PCH, while it may be dangerous, certainly even reckless, was not historically or objectively an act whose natural and probable consequence involved a high degree of the probability of death. It's not a motion about whether or not the collision was devastating. Everybody in this courtroom knows that it was. It's not a motion about whether speeding is inherently dangerous. It is. We can all agree on that. But implied malice murder requires more than just tragedy and more than just danger, Your Honor. To repeat that incredibly important standard, it requires proof that the natural and probable consequences of that act and that act alone, as one court put it, is nearly certain to cause death. That's the line between gross vehicular manslaughter and murder. And that's the evidence that the prosecution failed to provide to the defense, and that's the evidence that goes directly to that line.
the preliminary hearing where a magistrate found probable cause for murder was fundamentally compromised. because prosecutors sat on 10 years of government collision data from the very 0.8-mile corridor between Carbon Canyon Road and Las Flores Canyon that demonstrated, in cold hard numbers, that while
that we have now uncovered shows that there is chronic speeding on PCH. It shows that there are recurring collisions, one after another after another. It shows governmental recognition of those speeding issues and those recurrent collisions, and government recognition of a serious traffic safety problem in Malibu and on that particular stretch. But importantly, and most notably, that data also shows that fatal collisions are rare. Not just rare, Judge, extremely rare, relative to the volume of speeding, the volume of citations, the volume of collisions. On that precise 0.8-mile stretch, and this is
chronic speeding, reckless driving, and non-fatal crashes are practically a local pastime on that serpentine Oceanside Highway, exactly zero of the...
On that precise 0.8-mile stretch between Carbon Canyon Road and Las Flores Canyon, in the 10 years before this case, SWITRS, which, as the court knows, is called the Statewide Integrated Traffic Records System, SWITRS, identified 129 reported collisions. The actual case listing establishes this, and the government's own report establishes this, and it's run from the government's own database. Not a database that we created, a database they created and they had. Then Caltrans produced approximately 50 additional collision reports that were not included in the SWITRS data. So we have 129 from SWITRS and an additional 50 from Caltrans. And that was also obtained by subpoena by the defense after the preliminary hearing, and it was never produced in the discovery. Together, that's approximately 179 collisions on the same stretch of road over the course of 10 years. The only fatal collision in that combined
179 documented accidents in a decade resulted in a death, except this one, that statistical reality Jackson thundered, shreds the prosecution's theory that the natural and probable consequence of driving 1 or 4 miles per hour in a 45 zone is...
And that speaks directly to the objective element, Judge. The prosecution's entire theory at the preliminary hearing depended on treating excessive speed on this stretch of road as conduct whose natural and probable consequences involved a high degree of probability of death. That was their theory. They can't run from it, they can't hide from it. They said it, they theorized it, and that's what they presented to Judge Edgar. But the undisclosed government history, the 10 years worth of government data, shows exactly the opposite. Repeated speeding, repeated collisions, and not a single other fatal collision in 10 years on that stretch of road. Not one. And we didn't have that data to make that point in front of Judge Edgar.
An act so inherently lethal it amounts to murder. Instead, he says the undisclosed history shows the exact opposite. You can speed catastrophically on PCH and overwhelmingly walk away, or cause only property damage, which means the objective element of implied malice, a high degree of probability of death, simply isn't met, and hiding that from the defense.
The preliminary hearing, as the court well knows, is not simply a formality. It exists to weed out unsupported and grave charges before the defendant's forced to stand trial on those charges. The defense has the right to confront witnesses, to cross-examine witnesses, to do that meaningfully, to present evidence in its own defense, to impeach prosecution evidence, and to negate elements of the charges. And when favorable evidence is withheld from the preliminary hearing, the harm is not cured by saying, well, it's okay, they've got it now, they can use it before trial. The harm is that the magistrate's probable cause determination, Judge Edgar, 3 floors down, his probable cause determination was made on an incomplete record, and Mr. Bohm's statutory and his constitutional rights for the preliminary hearing, at the preliminary hearing, they were denied when they mattered